Somebody, I don't care if it's handwritten, get me an order, counsel.
Yes, Your Honor, I attempted to, and I will make.
Oh I hear you. Get me an order. Get a piece of paper, write an order so I can get her assessed.
Oh, yes.
Right now, I'm done. Step away from my podium.
A defense attorney stands at the podium with nothing in her hands, no order, no paperwork, nothing the court can actually use. The judge has heard this excuse before, and in about 60 seconds, she is going to say 5 words that end the hearing entirely. Step away from my podium. Let's back up to how this started. This is Genesee County, Michigan, a pre-trial bond hearing in the case of People versus Nicole Henderson. Presiding is Judge Simpson. Henderson faces a pending case involving alleged intoxicated driving, an out-of-county charge, and an allegation of malicious destruction of property. She has already been in custody more than 30 days. Her attorney, Nicole Sadie, is asking the court to modify her bond, and everything hinges on one piece of paper that, according to the court's file, does not exist.
I take it, Mr. Cook, that's why you are here today.
Yes, Your Honor, we're here for a pretrial as well as a bond review hearing. I was served a copy of that motion this morning. I was able to read through it. Most all the information in the motion, I believe, was already placed on the record, so I was already aware of all of this. So I'm ready for the on the motion. If the court wants a response, I'm fine with doing that hearing today if the court's inclined to do so.
All right. Well, go ahead, counsel.
My thought would be, as the court indicated previously, we want to see substance testing. Obviously, Ms. Henderson has this OWI case, the out-of-county OWI case, as well as the pending malicious destruction matter. My concern is making sure that she gets substance abuse.
At the top of the hearing, Attorney Sadie tells the judge she filed an emergency motion that morning, in person, and that she also tried to send the court a proposed order the day before. The order would authorize a remote substance abuse assessment for her client, conducted by an evaluator named Mr. Statman, so that Henderson can be released with treatment conditions instead of sitting in jail.
Person who is coming up to the podium now.
Your name?
Nicole Henderson.
Go ahead, counsel.
Your Honor, so this morning I did file an emergency motion in person regarding the bond. I'm not sure if you're able to hear that in the moment or schedule an immediate hearing on it. I was informed that I tried to communicate with the court. Ms. Henderson had secured Mr. Statman's services to do a substance abuse assessment. We understood from what you said from the bench last time that you want to read the assessment prior to making any form of a bond reduction. The jail was asking an order for remote participation for an order from this court. I did attempt to send proposed orders to the court, but there is an issue apparently with my emails, not just being received through this court.
There is just one problem. Judge Simpson never received it. Counsel, you sent an order to the court today, the judge asks. Sadie corrects her, no, it was sent yesterday. And then comes the first crack, the excuse that will define the entire hearing. Sadie says her email account was hacked the week before, through a fake party invitation link she clicked without thinking. She says she thought she had secured her account. She says she never got a bounce back notice telling her the message failed. In other words, as far as she knew, the order went through.
Here.
I back up a moment, counsel. You sent an order to the court today?
No, yesterday, and I had also sent a request for a remote hearing on Monday, but I showed Ms. Wielding my emails. My emails were sent, they were not received. I did have a hack event last week through one of my email accounts. It was a party invitation that was not a real party invitation. I never should have clicked on. I thought I had secured the emails, but I believe Ms. Wielding didn't receive them. I didn't get a bounce back, so I'll have to correct that issue. But I wanted to make you aware that I've attempted some.
Here's why that detail matters. In a bond hearing, the court can only act on what's actually filed and served. A judge cannot verbally approve a document she has never seen, and a jail cannot release someone based on an attorney's word that a form exists somewhere in cyberspace. If the order never arrived legally, it never happened. Prosecutor Cook doesn't dispute much of what's in the motion. He tells the court he already received a copy that morning, and most of it simply repeats facts already on the record. But he raises the stakes early, on the record, in open court. He says Henderson has serious health concerns if released, and in his words, concerns about what she might do to herself with her substance abuse, and whether or not she might harm or kill herself or someone else. That's not background noise. That's the entire reason this hearing exists.
And obviously, I think, as the court indicated, I don't know if it was last time or the first time that this case was up, there's some pretty serious health concerns for this defendant if she were to be released, and concerns about what she might do to herself with her substance abuse and whether or not she might harm or kill herself or someone else in the process of that substance abuse. So I just want to make sure that we are addressing that adequately before release. And I would be fine with whatever method that is, whether that's with Mr. Statman or with the individual that Agent Polaris stated. I'm happy to do whatever legwork I need to do to make.
Attorney Sadie pushes back, but not on the substance. She argues her client has resources most defendants don't, a stable job at General Motors with an employee assistance program that can get her a superior assessment faster than anything the jail can offer.
May I respond?
Go ahead.
Thank you. So the issue with the time is that Ms. Henderson, unlike some of the indigent defendants I've represented, actually has some excellent resources that she can use. And they are, I'm sure that Your Honor has heard this, but I would like to emphasize this. Now, Ms. Henderson, it is alleged that she has an issue that is with alcohol. And we know that withdrawal alcohol, although she's been incarcerated for more than 30 days, we know that there were physical effects and psychological effects that go along with getting rid of that addiction. The type of position that Ms. Henderson has allows her to go in without there being any harm to the job that she's held, which supports herself and her daughter. She will be indigent if she doesn't have another form of work or full-time employment. And it is very difficult when you're facing felony charges to be able to find employment, as I'm sure this court is aware. Now, this particular program she goes into, and she also suffers additional consequences once she's assessed. They do a professional assessment. That professional assessment makes recommendations. Ms. Henderson has to follow the recommendations. And if she does not, then her job becomes endangered. Her security is in jeopardy.
But there's a catch. Henderson's medical leave from that job ends this week. If she isn't released and evaluated fast, she doesn't just lose her freedom. She loses the job that was paying for the treatment in the first place.
Program through General Motors.
The program through General
Or
Motors.
the UAW.
There is an issue with Mr. Statman being able to assess her level of addiction, but those resources go away if she loses her job. This program hooks her up with.
But she's on leave, right?
Not for this week. This week is the week where it becomes, her leave becomes, she's expected to be back at work this week. Her leave is ending.
When did you leave in, ma'am?
I was supposed to return back Sunday night, July 6th.
Got it.
Now the second crack appears, and it's bigger than the first. Judge Simpson asks the most basic question a judge can ask. Well, then give me an order. I mean, if I get an order, I'll sign it. Sadie says she's sorry that she did email one, that those are the same emails that were never received, that she would have printed a copy that morning but didn't. She offers to fax it instead.
She did pay Mr. Statman. Mr. Statman's schedule allows for a remote assessment.
Paid him
Yes.
already?
Yes, he's been paid. It allows for remote assessment. The jail needs an actual written order from the
Well,
court.
then give me an order. I mean, if I get an order, I'll sign it. I wanted her assessed.
So that's where I'm so sorry that I did email one. Those are the emails that were not received. I would have printed one for you this morning. I can get one faxed if my email is an issue to you. I can fax the same email
Here's the pattern interrupt. The court's own probation officer steps in and confirms the timeline independently. Mr. Statman is ready. He can do the assessment as early as the next morning. He already has payment. This isn't a scheduling problem. It's a paperwork problem. That single fact removes the excuse entirely.
Did Mr. Statman indicate how fast he can get to her if I can get an order
by Friday.
by Friday?
That was my belief. He is making time for her. He waited yesterday. And I was waiting for communication from the court that you didn't receive.
All right. Just
The only thing I would add, Your Honor, is looking at the services that Agent Flora referenced, that at least according to their website, they can do within 48 to 72 hours of booking. It's a $200 cost. I understand the defendant may not have that, but in case
The delay isn't coming from the evaluator, or from the jail, or from the defendant. It is coming from a document that, by every account in this room, was never actually delivered. Judge Simpson lays out exactly what she wants. I just need to get her assessed. I need an assessment and a report, given all the circumstances in this case. How complicated can the order be? Sadie tells her it was a one-page order for a prior client. 1 page, that's all it would have taken.
okay. I just need to get her assessed. I just want an assessment and a report, given all of the circumstances in this case. How complicated can the order be for Mr. Statman?
It wasn't. It was a one-page order that I proposed.
Then can
Your Honor, would you like me to call Mr. Stanley?
if you would. My problem is that I think from the jail's perspective, I just need an order to get so that the jail will make the proper arrangements so that Mr. Statman can see her.
That's what they told me, yes.
And the place that you have is a 48 to 72 hour turnaround.
But we haven't reached the biggest contradiction yet, because now the prosecutor raises something the defense wasn't prepared for. Henderson has a daughter.
All right. So the problem's going to be I'm now here at Wednesday. Her leave ended, you said Sunday.
And I know that this court is aware you could put her on an alcohol tether. She does have court in Shelby Township.
That has counsel. That's always been an option. The problem is the circumstances of this case, and I am doubtful to. I'm not changing my mind on that. I mean, she needs help. We can fashion something so that the public's not at risk, she's not at risk. I mean, the bottom line reality to it is that little girl that was here the other day, her daughter, I can't in good conscience let this defendant out where she may be traveling with that child, if no other reason.
Full custody, no other parent in the home. And according to the record, this isn't Henderson's first pending case, it's her second, plus a prior. Cook tells the court that Henderson made statements described as of a suicidal nature, saying she didn't care what happened to her. The judge is blunt about what that means for her. I can't in good conscience let this defendant out where she may be traveling with that child. Sadie objects that there's no allegation involving the child in the vehicle. The judge's response is the kind of line that ends up quoted back at people. Counsel, that's not my point. I understand that we see things that happen, and you need a time machine.
Your Honor, I do not have discovery. I emailed discovery for discovery. I haven't received it yet. I just gave Raymond here a copy of the email I sent over I believe. Oh, I will give it to you. Sorry about that. I sent over, but I am unaware of any allegation, and please correct me. I am unaware of any allegation of her being inebriated in the car with her child.
Counsel, that's not my point.
I understand your concern, and I understand that we see things that happen, and you need a time machine.
Time machine, write that one down.
Basically, I understand that. I really do, Your Honor. And I really do feel that you're coming from a place of concern. I honestly do. But her daughter is in danger of losing, they're not married. She's been incarcerated. She's the one that has full-time care and custody. They're not on, her daughter doesn't need healthcare from the state. They don't need food stamps the way that things stand. So our concern is about what actually happened.
Counsel, she's got a prior, a pending, and another pending. She was a 0.235 in this case. She was making comments that were, and I'm not necessarily qualified to say this entirely, but were of a suicidal nature of what she would do to herself, and that she just didn't care. That's where she was.
By now, Judge Simpson has stopped negotiating.
Services.
You know what? I'm done arguing about it. I asked that something be done so that I could fashion something or be assured to let her out with as least risk as possible to herself or to the community. I haven't gotten that.
Your Honor,
Now I'm here today, counsel, trying to figure out how to make it happen. And so we can keep going around and around. Well, you can keep going around and around because I'm stopping. I'm not going around and around about this. I told you what I wanted. I told you what I needed to try to assess it, to let her out safely. I will do that, but I need it.
She tells the courtroom plainly, "I'm not going around and around about this." She offers to sign the order, deny the bond motion, whatever gets Henderson into treatment fastest. But she needs the paper in front of her, not a description of an email that supposedly exists. Sadie insists on the record that she has proof it was sent. The judge doesn't argue the point. She simply says, "I don't have it, counsel, so that means we can't do anything." Sadie agrees. That is correct.
Your Honor, may I have a written order denying the motion?
If you get me that order, I'll deny your motion, but get me the order that it gets her treatment, counsel. I don't know why this is so hard. Get the order.
May I explain?
Get the order.
In my email box, your court didn't. And
Get the order. I'm done. Take her back. I'll call the case back out, but I'm not going around and around. Get me the order.
I did.
I have,
Oh, go ahead.
I'm going to on the record address this so that it's clear. I have proof that I sent the order. I
don't have it, counsel. So that means we can't do anything.
That is correct.
I'm not saying whether I believe you or not. I can't do anything. I can't keep going around and around about this. I need an order so we can get.
Then comes the moment we opened with. The judge, done waiting, tells the room, "Get me an order. Somebody. I don't care if it's handwritten." Sadie tries to respond. The judge cuts her off. "Step away from my podium." Court goes into recess.
Ms. Polera, what were you going to say?
Yes, Your Honor. I just wanted to update the court. I did just speak with Mr. Statman. He indicated that if he has the order, he can do it as early as tomorrow at 10 a.m. He tried to do it.
Get me an order. Somebody. I don't care if it's handwritten. Get me an order, counsel.
Yes, Your Honor, I attempted to. And I will make.
Oh, I hear you. Get me an order. Get a piece of paper, write an order so I can get her assessed.
Oh, yes.
Right now. I'm done. Step away from my podium. Court is standing in recess.
When the case is recalled, something has changed. An order has finally reached the judge's hands, physically, on paper. She signs it on the spot. Statman can now perform the assessment the next morning at 10, with a report ready by noon. The hearing is adjourned less than 24 hours out, a fraction of the delay everyone had just spent nearly 20 minutes arguing about.
Court recalls case, People versus Nicole Henderson.
Morning again, Your Honor. Raymond Cook for the people.
Good morning, Nicole Shawty. I'm still present, and Ms. Henderson is walking up to the podium now.
State your name, ma'am.
Nicole Henderson.
All right. We have finally received an order. I've signed that order. Mr. Statman has indicated, Ms. Polera, if I'm correct, can see you tomorrow at 10. The next question I had for Mr. Statman, which I think we got cleared up, is that he can then have a report by 1 o'clock, noon, 1 o'clock tomorrow. Okay. And then what I'll do is I'll adjourn this hearing to July 9th, tomorrow at 3 p.m.
One written page. That's the entire gap between a defendant getting help and a defendant sitting in a cell for another week. If you've ever wondered why judges get short with attorneys over paperwork, this is why. Because in the justice system, an order that wasn't received legally never happened, no matter how many times someone says they sent it. Let us know in the comments what you would have done differently at that podium, and subscribe for the next case.